Hello and welcome everyone to the Wall Street Blockchain Alliance's weekly crypto roundup. Today is Friday, September 29th, 2023. My name is Quaranta, chair of the Wall Street Blockchain Alliance. Great to be here with all of you. Have our co-host, my dear friend, the mother of blockchains and legal guru, Josh Klayman, joining us today. And our special guest, the chair of our accounting working group, the one and only Dr. Stein Smith. Good to see you both. Our usual co-host, David Brill, couldn't join us, Josh. I think it was something about the yacht being parked somewhere in the Riviera. I'm not sure. We'll just have to put an air tag on him to track him. But it's good to see you both. For everyone in the audience, again, thank you for joining us on LinkedIn Live and on Twitter. Sorry, Elon, it's X. I keep forgetting that. If you do have questions for myself or our co-hosts, please do enter them in the chat function as well. And please do keep in mind that nothing discussed should be considered accounting, investment, legal, and tax advice. It's a rainy day here in the Northeast. Sean, Josh, it's good to see you both. Josh, your dedication crashing in a stairwell at an event is something that's really a marvel. And I just wanted to kick off. There's so much for us to talk about, Josh, and I wanted to give you an opportunity to say hello. I know we looked at SEC Chair Gensler testified again. There's a couple of other bills that have been proposed. But Josh, what caught your eye this week?
Well, for me, a lot of the attention has been about next week's trial,
Yes.
right, with SBF. So I think that's where a lot of focus, at least for me, has been, which has really brought into the fore some of the things that I think in my mind had receded a bit, right?
Yeah.
Because it seems like, even though it was less than a year ago that FTX said, all of that, everything happened, to harken back to SBF's tweet about what happened.
Mm-hmm.
But it really was less than a year ago. And so I think seeing what happens in the trial next week, I've been refreshing on a lot of points about that. Just for those who are listening, one important thing to think about for the case next week is we're not going to get into necessarily issues of whether any of the tokens are securities, because we don't need to, because those charges relate to wire fraud and other sorts of things that don't hinge on whether the digital assets involved are securities, much as if you think back to the NFT enforcement by the DOJ a while ago, where they didn't touch on that either.
Right. Josh.
By the way, as far as an event, I am at I'm in the stairwell outside of the Circle Forum, New York City today.
I always have this fear that security is going to come and try to escort you out of the stairwell at some event at some point, Josh. But thanks for that. And we've got other topics to cover as well. Sean, I wanted to bring you into the conversation. It's your inaugural episode with us for the crypto roundup.
First timer.
Yeah, and one of the things we focus on, and David and Josh and I talk about a lot of legislative and regulatory stuff and a lot of the court cases. Certainly, one of the things you and I often talk about that I'd love to give air to here, because of the accounting side of these conversations. Would love your perspectives. FASB put forward something that I think you and I talked about 2 years ago around recognizing gains or losses for crypto that's held on the books and records. And recently the IRS weighing in on the regulations around decentralized entities and how many of those might get wrapped up as being broker dealers in a world where we thought, wait a minute, those are coders, or how does this work? Sean, what have you been looking at, and what about those two particular issues really strikes you?
Yeah. So, first of all, the upcoming trial of SBF really does highlight, to my mind, just before diving into the other two items there, that really the main crux of the problems or the allegations, made against both SBF as a person and FTX as the entity, don't have to do too much with actually tokenized assets. The bulk of them have to do with controls, governance, and the complete lack of those that had existed at FTX allegedly. So on the update out of the FASB, actually, you and I co-authored a open letter to the FASB back in the fall of 2019. So it has been quite a while coming. And so the main sort of thrust here is that going forward and the actual ASC codification is going to take effect in 2025, but firms have an option to adopt early next year in 24. So basically now going forward, if you are a a company following US GAAP, meaning you are US publicly traded, you going forward now are going to mark to market any Bitcoin holdings on your books. And it really looks like to me that even though it was the crypto guidance, it really kind of looks like to me it's only going to pertain for now to Bitcoin as the general understanding. So I think it's an excellent first step forward, but it's only that first step, right? Because NFTs are not touched, privately issued stablecoins are not touched, governance tokens, DeFi are all still in the pipeline coming, hopefully. Now on the IRS side, the whole conversation around taxes and crypto, and really the whole DeFi space has been underway, sort of on the back burner since 2021, right? Because the whole broker dealer change was incorporated into that bipartisan infrastructure bill passed, I guess, in the fall of 21, and now it's going to take effect. And so there has been quite a bit of arguing and conversation over the last couple of years. But basically now anybody who touches any part of any DeFi operation, now granted, I'm no lawyer, but basically any
we have
developer,
a lawyer on
exactly any coder, developer, or third party who's involved in DeFi transactions, even at a very minimal way, is going to be captured under this broker definition, which obviously, depending on who you ask, is either good to add transparency, or I think personally will crimp severely the ability of DeFi to grow in the
Sean,
US.
how workable is that? And I don't want to overstate the simplicity or complexity of it, but if you're going to tell a decentralized wallet holder, you're responsible for the name, address, and tax ID number of the person on the other side of a trade. And for the record, identify the other side of a trade in a decentralized transaction, and then submit them a 1099. How are they going to be able to do that? And what happens if they don't?
So the anecdotal conversations I've had is that in terms of compliance and enforcement on these issues, that the real idea behind this, and again, just my anecdotal conversations, is to not try to make the actual DeFi entities, right? Because it's awfully difficult to trace who is behind a DeFi wallet, especially if they aren't here in the US, and especially if they are trying to not be obvious about it. So the main thrust, I think, is to try to, again, crack down and to focus on compliance with US investors utilizing DeFi protocols, be they based here in the US or overseas. So ultimately, the enforcement actions, as far as I understand it, and as far as I can imagine it, are going to be focused on the taxpayer side versus the entity side. And then also, just a quick anecdote here. It is hard for TradFi broker dealers. I won't name names, but it's hard for them,
right?
And it's hard for centralized players in the crypto space to issue 1099s that are accurate to every investor every year. And so asking people who have no background, have no expertise, and have no training to go ahead and to add that onto their duties, I mean, that's asking for problems.
Do you think IRS will approach it from an enforcement angle, or do you think the rules as they've put them forward just don't survive in their current form?
So I would say that the rules as they're currently being interpreted aren't going to survive contact with the first tax season, right? That just ultimately it's just unworkable to expect every developer and coder and every DEX member to issue all of this tax compliance work and to be able to get access to all of that data, right? EIN numbers and all the other information connected to the traders. So I just don't think that's going to work, and so it's going to ultimately come back to the enforcement actions.
It'll be interesting to see where that goes, Sean. And I think you and I had this conversation. I think it's October 10th or October 20th. Submissions of comments are open. You and I and some other members of the WSBA will be contributing our proverbial 2 cents to this, and hopefully that adds to how the IRS moves forward with some of this. Josh, I want to go back to you for a moment if I could, and I want to be respectful of the stairwell time. However limited it might be. On Wednesday, I feel like you're in the bunker right now.
Kind for them. Yeah.
On Wednesday morning, I poured the bowl of pop. Yes, the fire escape. I poured the bowl of popcorn and I went to the House Financial Services Committee hearing, and I watched the usual flame throwing from both politicians on the left and right, to and for SEC Chair Gensler. I don't know if you had the opportunity to see it, but I did, Josh, want to ask you something that's been the subject of conversations we've had in our legal working group and other meetings in the past. Shout out to Congressman Torres, who really questioned Chair Gensler, Josh, on what is a contract and what makes an investment contract a contract, and does Howie apply if a contract, quote unquote, is not necessarily directly present. And it really got to the idea, and he used this example that was really fascinating. He says, if I buy a Pokemon card, am I buying an investment contract? And his answer seemed to be no. And Representative Torres said, if I buy a tokenized Pokemon card, am I buying an investment contract? And he couldn't answer that. So I guess the question, Josh, becomes, you and I've had this discussion with others many, many times. Is tokenization the focal point from the regulator's perspective or Chair Gensler's perspective? Is the act of tokenization itself something that makes anything a security?
So it's a good question. I mean, I think let me sit back for a second. I think, and I don't know what Chair Gensler was thinking, what was going through his mind, but what I guess if I tried to draw some distinctions, right? If I just, for argument's sake, tried to draw some distinctions, I might say, well, this Pokemon card, it already exists. The company that created it already exists. It's not being pre-sold to me to build out the company that's going to be creating this Pokemon card, or that's, going to then create a television show or a game or something like that. So what I do think is sometimes if I, again, not necessarily my views, right, but just if I'm taking this angle for a moment, I think the tokenization piece in some ways has complicated some of the analysis, because a lot of times people are selling tokens before they have built out the enterprise, right, when it's just an idea. Mm-hmm. And so I think that who knows, maybe that was partly why he couldn't answer. But I also think, the SEC, as we've seen even in, interactions directly with them, where it's not just testimony of some sort, there always has been this sort of concern, at least when I've spoken with them, about, okay, but all right, we know what the law says, for example, Reg S, right? Like it's selling outside the US. But, this vision that there's, within the US, a giant vacuum that's sucking up all these tokens, right? And this idea that, okay, but you're creating a public market and it's going to flow back into the US. So what other steps might you take to stop that? And what you end up seeing is like encouragement, for example, that issuers that might be category 1 issuers, where they don't have to police flow back, or they might institute anyway some kind of transfer restriction period, almost like treating like something like debt, right? Like, and keeping it out of the US in that way. So who knows? But it is interesting. I mean, it is interesting, the lines of questioning and answers. I think it's also important to remember, and we have said this, all of us, I'm sure, is that Gensler, to my knowledge, is not a lawyer. Right. And so asking him whether something is a security and whether it changes, I mean, it's a legal question, and he may have a view, or he may want to consult his lawyers. I don't know. So what I would say, though, if it's okay for a moment, can we loop back to the IRS guidance for a second?
As you please.
Okay, so this is really more of like a question, I guess, for you guys. And certainly for those who are out there listening, Sean definitely is my go-to for questions of accounting and tax advice in real time, in the real world, with actual,
He gets way too many calls, and he gets way too many calls and text messages from you and I, Josh, by the way.
Highly recommend. But one of the things with the IRS's proposed rules, with the staking, right, and treating staking as I understand it, ordinary income when received, right, as opposed to, or as income when received, part of gross income when received, not just when sold. I'd love to know your thoughts about that. I also had an interesting conversation, or I was part of a larger conversation where the idea was floated about whether staking is a passive activity or an active activity. And I'd love to know your thoughts, not to put you guys on the spot, but I figured.
I'll let Sean kick that off.
Yeah, yeah, sure thing. Thanks for the easy question, Josh. So the whole conversation around any sort of staked income is a conversation that always generates very, very passionate answers on both sides, right? And I've been involved in those conversations, both in person and online. So always be sure to talk to your tax expert first, right? But I would say that based on every interpretation, every comment, and every sort of public statement out of the IRS, they are pretty much set on recognizing any staked income, not only when received, which is a whole other sort of nuanced issue there, Josh, but also when it is created. Even if technically USD staker aren't able to, on that date, for example, access those funds and to then pull them out. So at any point in time where if I've staked ETH, for example, and I'm earning those block rewards, at the time of the creation of those block rewards, that's income to me. Now that's pretty much the interpretation I've seen out of the IRS, and in conversation with tax lawyers who are involved in those cases, that's the interpretation out of the IRS. Now, in terms of the active versus passive, the only difference that I've seen there, again, just personally, is that then that can be used depending on if you're an individual or a entrepreneur doing this, right? As a business, that can be used to help determine whether or not any losses linked to that staking activity can be used to offset those earnings, or conversely, are they going to be counted as a hobby loss on your current year tax return? But in terms of how it impacts how it's treated from a tax point of view, active versus passive is a very interesting difference. But at the IRS, they aren't treating it differently. Yeah.
Sean, I gotta, Josh, if I could just interject there, I've got to kind of raise the flag here. I still don't understand how taxation upon the receipt of staking rewards makes sense. To me, that's the intellectual cousin of a wealth tax that says, hey, you made a return on your investment in IBM and it went up 30%. Even if you don't sell it, you owe some tax on that 30% upside. It just doesn't make intellectual sense to me.
So
I don't even know if that's a question. I'm just kind of making a statement, but I'd love your perspectives.
So personally, I am 100% with you, Ron, that I can create something. I can write a book. I can make a painting. I can grow something. I'm not taxed on that until it's involved in a transaction. And so that's what staking is. That's the argument that has been made multiple times. I've made that argument myself multiple times, but as far as the IRS is currently concerned, they aren't interested in that argument.
Do you see that sustaining as well going forward?
I would.
How is it operational? Like, how could that possibly be properly implemented by an individual who's staking, for example?
Again, Ron, it's always good to sort of have an eye on sort of the big picture trends, right? That at the exact same time that pending tax and compliance changes are crimping the ability of DEXs to operate here in the U.S. or to attract U.S. taxpayers, therefore making U.S. taxpayers more likely to go to players like Coinbase, who are centralized, publicly traded, currently being sued also by the SEC, just anecdotally. And so then it's going to make it, that sort of two-piece action is going to make it easier for the IRS to enforce compliance on U.S. taxpayers staking at U.S. crypto platforms, I think. So in terms of compliance, that just me as a non-lawyer, that's the way that I see it going forward. Now, in terms of how it holds up over time, that's going to be interesting, especially as these bigger institutions get into their own product offerings in crypto. That could then change that whole narrative also.
So as I think back just from my old finance hat, right, pre crypto, when I think about like LLCs, right, and members, and if they're taxed, I guess at K1, right, and if they haven't received the funds that they're being taxed upon, there's a well-worn path of how you treat that, and how the LLC or others might allow those payments to be made. I wonder if we'll see any sort of movement in the digital asset space in the event that the IRS does, in fact, go full steam ahead with that, just to see different. I wonder whether there will be something analogous in the staking setting.
Time will tell. I suspect, Josh. I wanted to pivot a little bit, and Sean, you had mentioned big picture a couple of times, and I'm really grateful that for that reminder to look at the big picture of what's going on. I want to make it a big international picture. One of the talking points we had put forward was Chase UK blocking crypto and crypto payments. What's your collective perspectives on this? And the reason I say that is I had the privilege to panel and join some colleagues from Europe in a conversation. And part of that conversation was whatever the US is doing, keep it up because it's just more opportunity for Europe. And I'm paraphrasing a little bit. What do you both think about these kind of debanking activities that are happening? And is this Operation Choke Point 2.0 continuing, and is it now spreading overseas, or is it kind of an isolated case? Do either of you have any thoughts about that?
Want to go first, Josh?
So I would say, at least as it's been explained, they've kind of attributed it to potential for fraud.
Right.
So at least that's what's being said. But it is a great question that Ron raises. Now, I can't speak as to any particular entity or any particular decision, obviously, because I'm at a law firm. And so, but what I would say is, although all of these views, they're my personal views, I would say it's a great question. We don't know what's going on behind the scenes. And certainly with the, suspected, quote, unbanking of crypto that we saw earlier this year, certainly we have seen bank regulators and others pointing to heightened risks. We've seen these heightened risks being pointed to by many regulators, whether or not we may agree that they are heightened risks. Yeah. So.
And even to that point, Josh, we recently saw the Fed put forward their risk assessment paper for crypto activities. Sean, I just wanted to give you an opportunity to weigh in there if you care to, or we can move on to other topics. There's always a lot to cover, but would love your thoughts.
Yeah, sure. And I don't work at a law firm, so I can speak a little more freely. What I would say there is that it's the most recent iteration of regulators and traditional financial institutions, trying to push back against the growing interest, investment, and adoption of tokenized assets, right? Both by institutions here in the U.S. and internationally. And it's also worth highlighting, I think, that there was I believe a pilot launch of a tokenized euro that had just rolled out earlier in the week. So it's no coincidence to me that at that same time that there were bans on other crypto assets being used at banks over, while not in the European Union anymore, it is the I believe top one or two trading partners for institutions in the UK. So overall to me it is another indication that there are regulators that I'm sure some of them are concerned on the risk side, but they're also wanting to get more of this stuff, meaning tokenized assets and investors using it, into existing guardrails. And it's awfully tough to fit that round peg into that square hole. And so that's why there are crackdowns, bans, and other restrictions being placed on these tokenized assets, indicating that there is need for more crypto-specific regulation, or if not regulation, guidance.
There are several regulators who would disagree with you, including a regulator who said not too long ago, and I hate to do it again, Josh, but I'm going to bring it up, that we don't need digital assets, we don't need digital currency because we already have them. It's the dollar and the euro, et cetera, et cetera. Let's move on from that. And again, thank you both for being here. Thank you everyone in the audience for watching. Thank you for the kind comment from LinkedIn user. I don't know who you are, but thank you so much. Any additional comments, please do keep them coming. I want to pivot to one little thing. Sean, I'd love to start with you. I'm going to rip up the script just a little bit. But I think in both our accounting working group and our legal working group in the past 2 years or so, we've raised SAB 121. And I just noticed a couple of days ago, shout out to, I believe it's Congressman Flood, who put forward proposed new regulation, Sean. You might like this one, the Uniform Treatment of Custodial Assets Act, that essentially is meant to counteract or potentially end SAB 121. Josh, we have clients and members across different ecosystems that have come to us, and we have large bank members who shall remain nameless that have said, what the hell? SAB 121 is killing us. How do we work in this? And Sean, certainly from an accounting and audit perspective, SAB 121 has certainly come up. I don't know if either of you have seen this proposed draft legislation, but do you think it has a shot? And what are your thoughts about the impact of what SAB 121's done?
Well, okay,
Just
thanks.
making you go first, Sean.
Thanks. Yeah. So the impact of the SAP 121, I think, has been just more efforts again out of the SEC, unfortunately, to, if not actively push companies out of holding assets for their clients, to make it seem more onerous and seem higher risk. And sort of the main issues there that I see is that, one, when combined, SAB 121 basically treating assets held under crypto custody as different from other assets held under custody. That's unusual, I think. Two, the Office of the Chief Accountant at the SEC basically issued what I construed as a open warning to any lawyers or any auditors or advisors trying to help companies with their crypto issues, including SAB 121. It really has sort of struck me as just more evidence of the anti-crypto, anti-tokenized asset stance out of the SEC. I do not think that it's helped. And I know earlier in the month, I had the privilege to interview Commissioner Peirce, asked her that question on that issue, and her and her team have been quite outspoken in their opposition to how that was created and then issued out to the marketplace. And I would agree, right, that it hasn't added, to my mind, much transparency. It has not helped sort of close any information gaps in the marketplace, and it's only made it seem more high risk to get qualified legal and finance experts to help these companies deal with these issues. So it has not helped, and I would be very interested in seeing this new bill put forward.
We'll be digging into the new proposed draft legislation, Sean, and share that. Josh, I just wanted to give you an opportunity. I don't know if your clients run into SAB 121 as an issue. I just wanted to raise that as a question. And one other thing, you mentioned Commissioner Peirce. For anyone in the audience who hasn't had the opportunity, and Josh, tell me if you disagree, her dissents of some of the SEC's decisions are masterfully written, whatever perspective you sit on, but would love your thoughts about that.
So first, with respect to SAB 121, yes, that's on everyone's mind. And I wasn't lying when I said Sean is my go-to for your thoughts about that.
Oh, yeah.
So I think even just parsing SAB 121 itself, right, which things are crypto assets, which activities fall within these sorts of identified activities in terms of custody, and whether there's a digital asset or crypto asset nexus to those activities. And then honestly, policy questions too, including, because as you've alluded to, or as you may have actually mentioned, if you think about some of the effects of this, and if we think about some of the proposed rules that the SEC has at least contemplated introducing, including the safeguarding rule, right? Whom do we think would be a qualified custodian that we might think of? Well, we might think of banks, but alongside all the activities by the Fed and the OCC and others saying, hey, you can't do these activities without our approval first. Then when you layer on SAB 121, the effects of that, when combined with, the capital like all sorts of other requirements that apply to banks that make us have faith in banks, right? The prudential regulation of banks, they don't really fit together so well. So it's, I agree with what you're saying in terms of, is SAB 121 just another way to try and keep the crypto space out of the traditional finance space? and to keep those things separate, which we have heard, from heads of regulators and others, in their personal view about the dangers of mixing those two, and the warnings that they've given about, financial crisis 2.0 or something like that.
I remember when 4 or 5 years ago when we mentioned crypto, both in accounting and legal perspectives, the idea was it's not systemically important. It's a fringe thing. Now it's a systemic risk to global, worldwide markets entirely. But I had a conversation real briefly, Josh, to that point with a banking colleague, and he said, look, being a qualified custodian potentially in the crypto space, but being saddled with SAB 121 is like being handcuffed. What can we possibly do here? I know we're just about out of time. I wanted to ask you both, and it's the same question, Josh, as you know, every week. What are you looking forward to? What will you be focusing on next week? There's just so much to focus on, but I'd love, Josh, what will you be looking at in the coming days? And then Sean, will get the same from you.
Sure. So, there's a lot happening next week aside from the trial. I know on Monday is the Fordham University, I don't know exactly,
Blockchain Law Summit.
Yes. So I'm really looking forward to that. And there's a lot of things that continue to unfold. I'm also, quite frankly, interested to see what happens with the potential government shutdown.
Is the SBF trial televised, or is there a visitors gallery kind of thing for that, Josh? I honestly don't know.
So I don't know. I assume so. I understand, not to plug any particular media outlet, but I understand that CoinDesk will have a number of reporters following it. So I imagine that
in real time.
Yeah. So, but I don't have personal knowledge about whether it's televised or whether that's something else.
Understood. Josh, thanks so much. Sean, what have you got coming up this week?
So what I'm going to be, watching is obviously as much of the trial as possible, right? Because I love that stuff. One, and then two, what I'm also going to want to watch is any aftermath sort of blowback based on Gary Genser's testimony this week. And then adding on to your point earlier, if the government does indeed have to, shut down, that also means that and I think it was 90% of the employees at the SEC aren't going to be working. And so then how is that going to impact bigger policy questions and also the actual status of some of those big ETF applications going forward, depending on how long this possible shutdown goes for. I'm going to be, eyeballing those and also anything to do with any privately issued stablecoins, any bills, or any entities involved in that space are always areas that I watch quite a bit.
Thank you both. Sean, like you, I will be looking and parsing through some of the ETF applications, including the delays. Interestingly, we were joking about it earlier this week with members of the WSBA. I was trying to get someone to give me the over-under on an ETF being approved before the end of the year. Josh, everyone in the meeting that was a WSBA member said it's not happening this year. But interestingly, I saw a report, I believe from Bloomberg late yesterday or early today, that 75%, they gave it a 75% likelihood, Bloomberg analysts, of an ETF being approved before the end of the year. Don't quote me on the source. I think it was Bloomberg, but that would make for some interesting stuff. I, too, will be looking at the trial and information. One last shout out for everyone in the audience. Again, thank you all for joining us. For those of you who may not yet have seen it, the WSBA's Crypto Investor Summit is taking place on Monday, October 23rd at the Players in New York City. Josh is stuck being a panelist, as so many others of our members across law and banking and beyond. This is an open public, this is a free event for WSBA members. There are a block of tickets available for non-members. If you're interested in more information and can join us, info@wsba.co, drop us a note, and this will be a CLE eligible event, Josh. So with that, I will leave it. Thank you both. Dr. Sean Stein-Smith, you'll have to come back. Josh, wherever you are going to be going over the next few days, it's good to see you both. We'll leave it there. Have a great weekend, everyone.
Thanks, everyone.
Take care. Bye-bye.
Okay.